my name is Gulnur Nurkeyeva. I'm a partner of GRATA International, and today we will address the most frequently asked questions of foreign construction companies which are planning to implement construction projects in Kazakhstan.
Can a foreign company enter into a construction contract in Kazakhstan, or does it need to register a branch?
A foreign construction company has the right to enter into an EPC contract, a construction contract. However, according to the requirements of the tax code, in order to perform the construction activities, the headquarters of foreign company shall register a permanent establishment in Kazakhstan. And the most appropriate form of such permanent establishment will be a branch.
Can a branch of a foreign company enter into such a contract?
According to the civil code, the branch is a separate structural subdivision, which is not an independent legal entity and accordingly cannot act as a party to a construction contract. However, it is allowed that, for example, the director of the branch sign a construction contract on behalf of the headquarters based on the power of attorney. I would like to emphasize here that the headquarters as a legal entity and the party to the contract is responsible for performance of obligations and all the actions of the branch.
Is it necessary to obtain any permits or licenses in Kazakhstan?
Yes, it's absolutely necessary to obtain a local construction license in Kazakhstan. In order to do that, a foreign company must have a license in the country of incorporation and at least 5 to 10 years of construction experience in the country of incorporation.
In the EPC contract, can a foreign company subcontract 100% of the volume of construction works?
No, it is not allowed. The construction law provides that it is not allowed to subcontract more than 2/3 of the total volume of the construction works. Therefore, the general contractor should perform at least 1/3 of the construction work. 1/3 of the construction work should be performed by the general contractor.
Can a foreign company enter into an EPC contract in US dollars?
Yes, but it should be taken into consideration that foreign regulations law of Kazakhstan considers the branches of foreign companies as a residence in the Republic of Kazakhstan, and two residents of the Republic in Kazakhstan shall sign contracts only in a national currency. However, since the Kazakhstani construction license, for example, will be issued to the parent company and the party to the contract will be the foreign legal entity, not the branch as we discussed earlier, accordingly, we assume that it is possible to conclude a contract in USD. But there is one more issue to consider. Design and estimate documentation for a construction project is subject to the state expertise and it approved in the national currency. And in most of the projects, payment is made in accordance with the design and estimate documentation, and the change of USD exchange rate is not a basis for amendments of design and estimate documentation. There are special thresholds and requirements for such amendments of design and estimate documentation.
Can a foreign design company prepare a design documentation for a construction project?
Yes, it can, but such design documentation must be adopted by design company which has the appropriate Kazakhstani design license.
Is foreign law allowed as the governing law of construction contracts?
Yes, the applicable law to the construction contract does not have to be the law of the Republic of Kazakhstan, but the terms of the contract must comply with the requirements of the Kazakhstan construction legislation.
Is it possible to submit disputes arising under construction contracts to foreign arbitration?
Yes, it is allowed. There is no restrictions on that for construction contracts. Foreign arbitration awards are generally enforceable in Kazakhstan as a matter of law. Kazakhstan is a member of New York Convention, and if a foreign arbitration award is obtained in another member country, such award should generally be enforced by Kazakhstani courts, recognized and enforced by Kazakhstani courts without the review of the merits, subject to compliance with qualifications set out in the convention and certain procedural rules of Kazakhstani law. However, in practice, the recognition and enforcement of foreign arbitral awards in Kazakhstan can be difficult. That's a pity, of course, but specific issues may arise with arbitration clause if one of the party is the state entities of Kazakhstan or state-owned enterprises of Kazakhstan. The best solution there might be AFC, Astana International Financial Court, or arbitration. AFC Court provides a common law court system that operates to the highest international standards to resolve commercial disputes. The AFC Court is separate and independent from the Republic of Kazakhstan judicial system, and its decisions are supported by a robust enforcement system in Kazakhstan. So no need to recognize such arbitral award, it goes directly for enforcement. For example, in AFC Court and arbitration, I have recently won 3 cases representing construction companies in disputes arising from EPC, PPP projects, where the employers were different ministries of government of Kazakhstan, with the amount of cases exceeding $20 million. Chief Justice and judges of AFC Court are among the most experienced and distinguished judges from the common law world, with global reputations for absolute independence and unconditional application of the rule of law.